Good morning. I'm Stan Purser from the Utah Attorney General's office. I will start a tad early, and so you will start your break early too. And hopefully that's the best part of my presentation. So I'm here to talk about some of the energy-related cases that the state, the Utah Attorney General's office, has been involved in. I'm going to talk about 3 cases. 2 of them have been decided within the last few months. One a win, one a loss, and the third case I'll talk about is still pending. I'll start with the bad news or the loss. It's a case called Eagle County, Colorado versus Surface Transportation Board, and it involves the Uintah Railway project. So the Surface Transportation Board regulates construction of railways, among other things. And in this case, the 7-county infrastructure coalition, which involves Uintah County, asked the board for approval to construct a railway connecting the Basin with a national railway line. And as we just heard, all of these sorts of projects also need to comply with other statutes, laws, including NEPA, the National Historic Preservation Act, and also the Endangered Species Act. So the coalition asked the board for an expedited approval process, an exception from the normal application process. And it also asked the board to bifurcate its process, to look at the railway merits of the project while these environmental reviews were going on. Ultimately, the board approved the project based on the merits of the railway project and based on the environmental approvals that had been issued. So environmental groups sued, and including one county from Colorado, and they argued a host of things, but primarily that the STB's approval process did not properly consider all the environmental impacts that this project would create. So the parties, the defendants or the respondents in this action, the federal government and the 7-county coalition, they filed briefs addressing the petitioner's arguments on the merits. Utah was not a party to the case, so we filed what's called an amicus brief, a friend of the court brief. And so as to avoid repeating what the parties had argued in defense of the board's decision, Utah focused on the benefits that this railway project would provide for the basin, for the state, and whatnot. So when it came to the ruling, this went before the United States Court of Appeals for the District of Columbia. So that's in Washington, D.C., because they have jurisdiction over the STB's rulings. The court rejected some of the petitioner's arguments, but affirmed others. Primarily, the court said that the board had failed to consider all the necessary environmental impacts that this railway project might create, and that included what they refer to as the upstream and the downstream effects, meaning if this project came to fruition, it was anticipated that there would be more drilling in the basin, and that was one effect that the board needed to consider, and also the probability that the oil that was produced would be transported to the Gulf states. So in the court's view, you had to consider the environmental impacts from start all the way down to the Gulf states, where this oil would be shipped. And the STB didn't do it because the STB said, it's kind of unknowable what all these impacts would be. We don't know the exact refineries it's going to go to. And the court just disagreed and said, you know enough to make an educated guess about what some of these environmental impacts would be. The court also found that the STB had failed to consider what it called the downline effects, and that was how would increased rail traffic, not just on this new rail project, but on existing lines, how would that impact the environment or other considerations? And the court said that the STB had failed to consider that, particularly the potential for increased train accidents or increased wildfires and the impact that oil leaks on the train lines might have on water resources. And then to top it off, the court also found that the board had not conducted a proper Endangered Species Act analysis. On the merits of the railway, given everything I've just said, the court said, the board also failed to properly consider everything they had just said that might be problematic about this project, including the financial viability of the project, and to weigh those concerns against the benefits that the state and others had said would accrue from this project. So in the end, the court vacated the board's ruling approving the railway project and remanded, which means they sent this case back to the Surface Transportation Board to proceed again and do a proper analysis. Any questions on that case?
How can the judges require those actions when you have NEPA, the National Environmental Policy Act, guiding you? So, I mean, where do they get the power to override NEPA to tell you you have to do this, you have to do that? Because NEPA's got the rules and the regulations within the act to tell you what you need to do.
So what the court did is it was interpreting NEPA, and the court said this is what NEPA requires, what it doesn't require, and they said NEPA required the board to consider these additional factors.
And that's their own opinion, right? Because we've had hundreds and hundreds of projects done in this country over time and never had that kind of opinion. Where you got to take this from cradle to grave. You got to take it from the Basin all the way to Houston. Where else has that ever occurred? Ever.
Yeah, and
It's precedence, right? It's precedent. And if they continue to have that kind of power, that kind of control, and require that extensive of a NEPA analysis, we're done. How can we ever get anything permitted?
well, so I am not here to defend the court's decision, but under our system of government, the judges, when they interpret the law, you're right, it does become some precedent. They looked at what they thought were some similar cases from other contexts to require this extended view, but that was one of the arguments that the parties made is, in this context, you don't have to look at the upstream or downstream effects, especially when it seems kind of speculative at this point. The court disagreed.
And they can do that.
Yeah, they do. Yeah.
3 judges know more than hundreds of scientists, resource people with thousands and thousands of hours put into this assessment.
Yeah. Other questions? The next case is better news from the state's perspective. It's called it's called Hill, Utah versus Environmental Protection Agency. And this case arises in the Clean Air context, or the Clean Air Act context, specifically the Regional Haze Program. So, as some of you or many of you may be aware, the Clean Air Act regulates or creates what's referred to as a cooperative federalism approach, where the federal government sets air quality standards and the states are allowed to develop plans to meet those standards. So under the Clean Air Act, the states propose or adopt a SIP, or a state implementation plan, explaining how the state will attain the federal air quality standards that the Clean Air Act and the accompanying regulations require. If the EPA determines that a state SIP is deficient, then the EPA can impose a FIP, or a federal implementation plan, to help the state attain the necessary air quality standards. So in relevant part here, this Regional Haze Program, it required Utah to develop a SIP regulating air quality in Class 1 areas. So think of national parks, national wilderness areas within the state. And in particular, the state SIP had to explain how the state would regulate major stationary sources. In other words, power plants that were emitting potential pollution. And this plan also requires the state to explain how it's going to regulate those power plants as far as the BART, or the best available retrofit technology. And that can vary depending on the source of the emission. But it basically just means the state needs to implement the best available option to reduce the emissions from that source. So the EPA has a rule to provide more guidance to the states on this Regional Haze Program. And under that rule, a state SIP can show compliance with these BART requirements by either implementing the BART requirement or choosing an alternative remedy if that alternative achieves greater reasonable progress toward visibility than would the BART. And there's 2 options for states under this alternative plan to show that it achieves greater reasonable progress. They can use what's called the clear weight of authority method, or they can use air quality dispersion modeling. In this case, Utah proposed, it was a revised SIP at that point in 2015, using a BART alternative based on the clear weight of the evidence standard. The EPA reviewed the SIP and ultimately denied it in what the EPA said was a very close call. And given that it was a close call, the EPA invited Utah, said, you're welcome to propose a revised SIP. So Utah did that in 2019. This revised 2019 SIP proposed the same substantive plan as the 2015 one, There were no changes, but instead of using the clear weight of the evidence rule or method, it used a air quality dispersion model to show that this plan that Utah has been proposing shows greater reasonable progress than the BART alternative and would cost a lot less money. So the petitioners here, a group of environmental entities, well, the EPA approved that revised 2019 plan. So that made petitioners mad because they thought, what is going on here? This is a complete flip-flop by the EPA, whereas in their view, this was sort of the undercurrent of their brief. Under the Obama administration, the EPA had denied this exact same SIP. Under the Trump administration, the EPA had approved the exact same SIP. This is an arbitrary flip-flop. It can't stand. Specifically, their argument was that, you know, this dispersion modeling that the Utah had used and PacifiCorp used was flawed, and it didn't actually show any improvement over BART. And the EPA had not responded to some of these criticisms before finalizing its approval of Utah's SIP. So given this, we had a little bit of concern whether the EPA, which was now under the Biden administration, we weren't totally sure whether they were going to defend their ruling in court. And in fact, as they had done across the country, they asked for a stay of the briefing to review the ruling to see if it complied with sort of the new policy, the new policies of the Biden administration. But in the end, the EPA, after this review, they stuck with their approval of Utah's SIP. They wrote a really good brief defending their decision. PacifiCorp, who was also a party to the case, submitted a very good brief focused on the modeling. And Utah, not to repeat all these arguments, it submitted a brief focused on the cooperative federalism aspect and argued and showed to the court, in fact, this was a perfect example of working together with the federal government. And in fact, in developing this 2019 revised SIP, the state and PacifiCorp had worked with EPA to make sure the modeling was right, and EPA had given feedback. So it was a very, very back and forth approach. In the end, the court, this was the 10th Circuit this time, the U.S. Court of Appeals for the 10th Circuit, they affirmed the EPA's decision, approved Utah's SIP. And this SIP process for the regional haze program is in phases, and this decision was as to the first phase. I believe we're now in the second phase, so we're sort of going through the same process of developing and getting approval for a second phase FIP, or SIP, sorry. Any questions about that case? Hill, Utah versus EPA?
Does that affect the finance of the power plant?
That was not one of the power plants at issue. The four power plants were the Hunter Units 1 and 2 and Huntington Units 1 and 2, all owned by PacifiCorp. So the final decision, well, sorry, not decision, this last case is still pending. And it's pending in the 10th Circuit and in the DC Circuit, and I'll explain why that is. So this is also a Clean Air Act case, but it involves the Good Neighbor program, which means the Clean Air Act also regulates emissions from one state that potentially are problematic air quality-wise for another state. So the air goes across state lines and causes problems. And the focus for Utah was on whether Utah was contributing to the air quality problems in Colorado. And under the clean air standard, the state has to regulate or do something about these emissions that, quote, contribute significantly to air quality problems in other states. So Utah, to do this, had worked with the EPA to determine whether Utah contributed significantly to Colorado's air quality problems under the EPA's traditional weight of the evidence analysis. And based on that analysis, based on that traditional analysis that the EPA had used for years, Utah concluded that it didn't contribute to Colorado's issues. And in fact, Colorado had concluded that we think we're going to get beneath the Clean Air Act's air quality standards just on our own by doing our own efforts within the state. So Utah submitted this SIP in early 2020 and didn't hear anything from the EPA for over 2 years. And then a little more than 2 years later, the EPA came out with a proposed rule imposing a FIP on Utah and about 21 other states. So that was out of order, and Utah was also like, okay, this seems like a big clue that the EPA wants to deny our SIP. And several weeks after that, the EPA did propose a rule that denied Utah's Good Neighbor SIP. And essentially, the EPA did not, because it involves so many states in part, that the EPA just didn't provide a lot of analysis of Utah's SIP. It was about one paragraph. And it essentially just disagreed with Utah's analysis and the method that Utah had used. So Utah, along with many other states, probably at least 21 states who had had their SIPs denied, they challenged the EPA's ruling. And the way this works, so because there was a SIP and a FIP under the governing law, Utah had to challenge the denial of its SIP in the local circuit court, which for us is the 10th Circuit. It had to challenge the imposition of the FIP in the DC Circuit because it was a national sort of federal plan. And so this case, this ongoing case, is a proceeding in 2 courts. The challenge to the the challenge to the SIP is more advanced. Utah and parties on Utah's side have already filed their opening briefs. And in summary, Utah is arguing that there are at least 3 problems with the denial of its SIP. One is that the EPA took just too long, 2 years, and Utah feels like it was sort of a bait and switch. We had worked with the EPA using their historic method, this weight of the evidence, this totality of the circumstances test to show that we weren't contributing to Colorado. And in the interim, this 2 years of radio silence, the EPA had said, nah, it actually prefers this other methodology, this 4-factor test that Utah didn't use. So Utah's arguing that's arbitrary. You can't do this bait and switch. You can't wait 2 years and then just deny our SIP. The state is also arguing that EPA exceeded its authority. Under the Clean Air Act, the EPA has to approve a SIP that, quote, meets all applicable requirements of the Clean Air Act. And the state's position is our SIP did that. There's nothing in the Clean Air Act or the regulations that requires the state to use the EPA's preferred method, this 4-factor test, rather than its historic test, the that talks about the totality of the circumstances. And finally, we're also arguing that the EPA rejected or ignored sort of the unique ozone transport issues that exist in the western states, which the weight of the evidence or the totality of the circumstances test by definition includes, because you can discuss and consider a lot of different factors unique to Utah, unique to the West, unique to Colorado, that impacts whether our emissions are affecting Colorado. And the EPA's rejection of this test, we're arguing it's arbitrary because it goes against the EPA's historic approval of this test. In fact, EPA had approved Arizona's use of this test in the past. So the good news from the state's perspective, because these SIPs can be very expensive to comply with, also, or the denial of the SIP and the imposition of the FIP, during the pendency of this case, Utah asked the 10th Circuit to stay, to halt the EPA's order denying the SIP. In order to get that, the state had to argue that we have a substantial likelihood of success of winning the case. The 10th Circuit agreed, and at least so far has said, okay, we're going to stay the denial of the SIP, and because the SIP denial has been stayed, that means the FIP also can't be imposed on the state. That doesn't mean Utah is going to win, but it's a positive sign at this point. So that's pending. We think a briefing will be completed in October. The case will probably be argued early next year, maybe February or March. In the meantime, the FIP challenge is ongoing in the DC Circuit. That involves many, many more parties around the country and is moving at a slower pace. Any questions on this last case? Thank you all.